This video is made for educational purposes only and cannot be taken as legal advice. As far as I can tell from this judgment, the doctor still works for the NHS, which in my opinion is concerning and alarming. Lady Justice King. This is an appeal by the mother against orders made by H.J. Dawson in private law proceedings in relation to her daughter, A, who is rising 7 years of age. The orders now challenged were made on the 20th of May 2021 and provided that A should live with her father by the final confirmation of an existing interim order made in August 2019. Provided for ongoing contact by A to her mother on a professionally supervised basis every fortnight for up to 6 hours. Prohibited any further application under the Children Act 1989 being made in relation to A for a period of 2 years without the permission of the court pursuant to Section 91(14) of the Children Act 1989. By an application notice filed on the 15th of June 2021, the mother applied for permission to appeal against each of the orders made, including the refusal to grant an adjournment. Because the application was made from orders made by a Tier 2 circuit judge in private law proceedings, the avenue of appeal was to a judge of the High Court under Part 38 of the Family Procedure Rules 2000, FPR. On the 9th of August 2021, Cohen J. granted limited permission to appeal, restricting the appeal to the question of contact and the making of the S-91(14) order. He refused permission to appeal against the order confirming that A should live with the father or the refusal by the court of the mother's application for an adjournment. Pursuant to FPR, the appeal was transferred to the Court of Appeal, Cohen J. having considered that the appeal raised an important point of principle or practice. The mother subsequently applied to renew her application for permission to appeal based on the rejected grounds at an oral hearing. The hearing took place on the 5th of October 2021, at which Cohen J. refused the application. The issues before this court are whether the judge was 1. Wrong to make a supervised contact order without specific provision for that contact to progress to unsupervised contact, and if not. 2. Whether, in any event, the making of an order under Section 91(14), coupled with a supervised contact order, placed an impermissible fetter on movement towards unsupervised contact and to the development of a more natural relationship between mother and child. The background is that the mother is originally from Hungary. She is a medical doctor and intermittently works in hospitals on locum contracts in various parts of the country. The mother has 3 children from earlier relationships. The mother and father formed a relationship in 2013 and A was born in 2015. In April 2017, the mother returned to Hungary, leaving the 4 children in the care of the father. 6 months later, she returned to this country and announced her intention to relocate to Hungary, taking all of the children with her. The father immediately applied for a prohibited steps order to prevent this, but it would appear that the parties reconciled before an order was made. In May 2018, the father agreed to the mother taking A to Hungary for 2 weeks for the purpose of A undergoing medical treatment. The other children remained in England with the father. A was not returned in accordance with the agreement. In August 2018, the mother told the father that their relationship was over, and in October 2018, and not having been returned to this country, the father issued child abduction proceedings for the return of A to this jurisdiction. In fact, unbeknownst to the father, the mother had already returned to this country, and in October 2018 she made an application for a child arrangements order and offered the father 1 hour's contact each week to be supervised by her. The mother's unsettled lifestyle continued. She moved to Hastings without informing the father, and then in June 2019, she moved to Northern Ireland. The father first became aware of the mother's relocation when a Northern Irish contact centre contacted him to inform him that contact would now take place in their premises in Northern Ireland. The mother subsequently failed to comply with a court order to return A to England and to surrender A's passport. As time went on, concerns about A's welfare were such that a children's guardian was appointed to represent A's interests in what was to prove to be long-running and destructive private law, child arrangements proceedings. Eventually, sufficiently worried about A's welfare in the care of her mother, the children's guardian took the most unusual step of making an urgent application for the residence of A to be forthwith transferred to the father. The application was granted by the judge on the 21st of August 2019 and subsequently appealed by the mother. The mother's appeal against the transfer was dismissed by Cohen J. and A has lived with her father ever since. At a finding of fact hearing in October 2019, the judge held that the mother had deliberately placed barriers in the way of the father having a natural relationship with A by taking planned and covert steps to relocate some distance from the father. I have described in only the barest detail the exorbitant court proceedings which have taken place. When considering the mother's appeal against the terms of the contact order and the making of an order under S91-14, it is necessary for this court to also consider the judge's findings as to the impact of the mother's campaign against the father and therefore upon A. In evidence, the father referred to receiving 80 emails in an 8-week period from the mother, each complaining about his care of A. Complaints were also made by the mother to the police and social services, one example being an untrue allegation made by the mother to the police that the father had committed a sexual assault on the mother's older daughter, an allegation which was inevitably investigated by the police. The father spoke of the huge impact which the various formal complaints made by the mother had on his home life and on A, involving as it did a number of police officers and social workers coming to make inquiries and carry out risk assessments in order to determine A's safety in her father's care. Discussion of contact. The judge held that if contact were unsupervised, the risk of abduction would be high. It is likely that the mother would denigrate the father to A given her unshakable belief that the father is a serious risk to A. That the mother would use unsupervised contact as an opportunity medically to examine A or have her examined in an attempt to prove that A is abused, unwell or badly cared for by the father. The judge therefore concluded that although A's relationship with her mother is important and best achieved by direct contact, the risk of the mother acting in a way that would be detrimental to A's well-being if it were unsupervised is high. The judge went on. Unless and until the mother is able to accept appropriate therapy to modify her emotions and her presentation, she is likely to influence A, with all her concerns or prejudices. I consider that supervision is a protective measure for A. It will stop her being conflicted emotionally and will prevent her from fearing that her home with her father is likely to be disrupted by the mother. The judge ordered the mother to pay the cost of professional supervision which the mother says she can ill afford as a locum doctor. The guardian expressed the view that if the planned 6 hours a fortnight of contact was unaffordable, the duration of the contact visits should be reduced rather than the frequency. Ms. Scotland on behalf of the mother sensibly accepted that in the light of the findings of fact made by the judge, in respect of which the mother has no permission to appeal, she cannot realistically challenge the judge's conclusion that contact should, at present, be supervised. Ms. Scotland emphasised to the court that whilst on the facts as found by the judge she had no alternative but to accept that the judge was entitled to conclude that contact has to be supervised, the mother does not accept that outcome or that supervision is either necessary or appropriate. I am entirely satisfied, as was the judge and the children's guardian, that this is one of those unhappy cases where the inability of the mother to regulate her behaviour in the interests of her child means that the choice was not between supervised and unsupervised contact, but between no direct contact or supervised contact. The judge rightly considered the importance of contact between A and her mother on the one hand, and the need to protect her on the other. I am satisfied that Ms. Scotland's concession was well made and that the judge had no alternative but to order contact to be professionally supervised. That view is reinforced by the intemperate and wild allegations made by the mother to the court in writing immediately after the hearing, allegations which when put together with her resistance to the highly specialized therapy she needs, as opposed to her stated willingness to have some therapy in the form of counseling CBT from her GP, make it likely that A's welfare will require contact to be supervised for some time to come. Before considering the way the mother puts her case in this appeal, it is worth placing the REP guidelines into a modern context and also considering how the provision in Section 67 of the Domestic Abuse Act 2021 may impact upon the guidelines when the time comes for that section to be brought into force. Although the guidelines have substantially withstood the test of time and have received the endorsement of this court on a number of occasions in the intervening period, the fact remains that they were set out in April 1999, some 22 years ago. In the intervening period, the forensic landscape has changed out of all recognition. Amongst the many advances is the advent of the smartphone and of social media in all its forms. Of particular relevance in this context is the almost universal use of email as a means of instant communication. Another development of relevance is that as a result of the withdrawal of legal aid in the majority of private law cases, a large proportion of parents are unrepresented and therefore do not have, as the judge described it in the present case, the steadying influence of legal advisors. One of the consequences of these changes, which is seen not uncommonly in private law proceedings, is that the other parties, and often the judge him or herself, can be, and often are, bombarded with emails from a parent, whether male or female, who is representing him or herself. Such behavior may be the result of anxiety, but in other cases, as in this case, it is part of a campaign of behavior by one parent against the other, which amounts to a deeply disturbing form of oppressive behavior on their part. Regardless of the motivation, behavior of this type, as exhibited by the mother in this case by way of an example, is deeply distressing to the parent who is the subject of such abuse and litigation at this level, and is highly debilitating to each of the parties and to their children. All too often such communications are ill-considered and ill-judged, with the consequence that every minor dispute or misunderstanding is met with an application to the judge. More importantly, the distress and anxiety caused to the other parent and to the children at the center of such a raging dispute cannot be overestimated, nor can the damaging consequences where the focus of the litigation veers away from what, on any objective view, would and should be regarded as the real issues going to the welfare of the children concerned. Conclusion. In my judgment, the submission made by Ms. Scotland that the making of the Section 91(14) order in addition to an order for supervised contact is wrong in principle, is without merit. It goes without saying that in the same way that leave to make an application following the making of a Section 91(14) order cannot be conditional, equally Section 91(14) cannot be used as some sort of fetter designed to prevent supervised contact progressing to unsupervised contact for the duration of the order. Every case must turn on its own unique facts, but what has to be borne in mind is that whilst a court can make both a supervision order and an order under Section 91(14), in any individual case, each has to be considered separately on their merits. That is not, however, to say that, as here, the same facts and features of a case may not lead a judge to order both supervision of contact and a Section 91(14) order. The orders made by this judge, far from acting as a fetter on the establishment of a more natural relationship, facilitate contact in circumstances where absent supervision, A's welfare would have necessitated indirect contact only. Quite separately, the Section 91(14) order was essential in order to give A and her father much-needed respite from the mother's unremitting campaign of harassment. It follows that, if my lords agree, I would dismiss this appeal. Lord Justice Newey, I agree. Lord Justice Arnold, I also agree.